Good morning, everybody. It is bright and early. It is Friday, September 2nd. Many of our teachers are getting ready for returning to school. And this, of course, is the last day of OJEN's 2022 Summer Law Institute virtual webinar series. My name is Nat Paul. I am with OJEN's Educator Support Department. I'm going to start by saying thank you to everybody who's been part of this, because of course, this is the ultimate session for the Summer Law Institute. Welcome and thank you for coming. You've managed to make your way to a hot one. So I know that we are joined from people from all around the province. Myself, I'm speaking from Toronto, which of course is the traditional territory of the Mississaugas of the New Credit First Nation, as well as Anishinaabe, Haudenosaunee, Wendat, and Huron Indigenous peoples whose stewardship of the land and relationships we share here make it possible for us to meet like this. As an organization, OJEN works in Ontario as a not-for-profit and engages with both the education and legal systems. And so because of this, we have to acknowledge as well the ways in which these institutions have contributed to the erasure of these communities and to support reconciliation in every way possible. It's my very great pleasure to introduce our speaker for this session. Justice Lorne Sossin has provided this presentation several times in the past, and we are very grateful to have his comments and insights again once this year. He has to be in court immediately after this, and I am committed to making this happen. So I'm afraid that if I were to try and point out every single remarkable thing he's done, I'd be guilty of, justice delayed and all that. But of course, he sits on the bench for the Court of Appeal for Ontario. It is not his first gig. Like Johnny Cash, he's been everywhere, man. He was elevated to this position not long after his appointment to the bench of the Superior Court, beforehand providing professional legal education in his capacity as the Dean of the Osgoode Hall Law School at York, as well as Associate Dean at University of Toronto, inaugural director of that center's Center for the Legal Profession. His range of expertise and contribution is phenomenal. It includes litigation, research, teaching, publishing in fields that range from legal ethics to constitutional law to access to justice, as well as research and advocacy for actually bettering the performance and accountability of the justice system. Justice Sossin brings all of this experience and passion to bear with us today. So on behalf of OJEN, I turn it over to you, Justice Sossin, with our deep thanks for your time and your insights. It's all yours. Take it away.
All right. Well, thank you so much, Nat, for the kind introduction. Jess and the whole OJEN team for including me. And it is such a group of kindred spirits that I'm privileged and honored to come along for the ride with from time to time. And I've been associated with OJEN for a good part of my professional life back at law school and now on the courts. But it's really because teaching law is a labor of love, and that's why I have so much admiration for what you do, and especially taking the time in that precious back end of the summer to participate in the Institute and get a bit rejuvenated in your own passion for these topics, and more importantly, how to convey what's meaningful, challenging, and I think always engaging about these questions for your students. So that's really the goal of this session, to talk about, what are the cases that have moved the dial at the Supreme Court over the last year, and some other developments in hopes that it will animate some of your work on keeping the curriculum fresh, be aware of, the areas that are unsettled, and we've got a few key ones this morning to talk about that I think translate really well into classroom dynamics. And you're welcome to pose questions, offer comments at any point, and they'll be conveyed. And I've left some time at the end to focus on that. So I know interaction is a challenge even after your first coffee on a Friday at the end of the summer before the long weekend. But I know these are these cases stimulate thoughts on your end too. So whether now or at any point down the road, and you'll have access to my email if you want to follow up on any of this, do reach out. And I think Nat's going to make sure there's hyperlinks to the cases we're discussing. They're also hyperlinked in the slide deck. So one way or the other, you will have access. And I'm just going to start sharing my screen now. And the slides, again, are just a bit of a backdrop to provide some structure and focus. But I assume they'll be available as well, along with the recording of this, if you want to treat it as a resource to come back to later. So
we really do. So thank you very much for that. That's appreciated. Great.
No, that's a pleasure. And Nat, are you seeing the slide deck at the moment?
Everything looks good. I'm going to pop off of camera, but so this looks great. If you need anything, just whistle, and Jess and I will come and fix everything we can immediately.
All right, will do. And again, this, as always, at least for me, is a team effort. And I want to thank Jesse Abel, Raouf Asimov, and Aaron Sobat, two clerks from the Court of Appeal on the last rotation, who helped develop which 5 cases we're going to talk about. They each came with their list. I had my list, and we hashed it out for a little while as to which would be the top 5. It was about 2 or 3 on all our lists, but then some interesting debates on the rest. And Aaron Sobat, who's new clerk at the Court of Appeal, has helped clean up the slides and make sure things are ready to go today. So let's dive in. The 5 cases, well, one's a bit of a cheat because it's a set of 2 cases, companion cases, Sullivan and Brown. I know you, many of you will have already had a presentation on involving counsel for Mr. Sullivan and Leaf, and so I won't retread that material, but for those who may not have participated, we'll give you a quick summary of what you need to know as well. We'll talk about the much talked about City of Toronto and Ontario case. This is one on the changing ward boundaries during the municipal election here in Toronto, and it's election season again in Toronto, so it's on people's minds for sure. Bissonnette, which is the case that dealt with how long someone can be sentenced without parole, and whether those sentences can be added on top of one another to effectively remove any chance or hope of parole whatsoever, and whether that violates the charter. The Stairs decision, which is again one that attracted a lot of attention on the balance between rights of privacy in one's own home and the rights of the police to search incidental to an imminent risk situation, which we'll talk about in the context of that case. And finally, the Keel decision, which dealt with rights of self-defense and how that operates in the context of some new legislation. Mention a case or 2 to look out for in the year to come, and some other notable developments at the court. This is how the court, Supreme Court judges looked up until very recently, and you'll see in the upper right corner my former colleague and friend Justice Mahmoud Jamal, who represented a landmark appointment in the first person of color to join the court, a racialized community member. And you'll see in the bottom left, the second from the left was Justice Michael Moldaver, who retired shortly after this picture was taken. You'll also notice Justice Brown in the bottom right is the one who didn't get the memo on what to do with your hands during this photo. So he always thinks his own way, and this is a nice visual representation of it. But of course, after the retirement of Justice Moldaver, we've had another landmark appointment, hot off the presses, in the sense that Justice Michelle O'Bonsawin was nominated, had a hearing, formally appointed, and actually just sworn in yesterday. So all of this has happened in the last couple of weeks, in a whirlwind in her life. And of course, as the first member of the Supreme Court from an Indigenous community, an Abenaki community member of the Odanak First Nation, Justice O'Bonsawin brings a distinct vision, perspective, and experience to the court that many have argued it's been lacking since its inception. So this will again be an important appointment, and the process was also much discussed. This again is Justice Abontwin being appointed right from the Superior Court, but someone who's had 5 years on the bench, and prior to that, important experience in the mental health fields, in working in-house in large institutions like the RCMP, Canada Post, healthcare sector, so brings wide and deep experience to the court. But again, the court is beginning to look like the rest of the country, and beginning to bring perspectives that are not the ones it historically has only drawn on. So many will be looking to see how those changes actually lead to different thinking, different decisions, different perspectives, different styles on the court. So lots of important work to come from the community of observers who have been calling for this, and will be watching carefully to see the impact it has. So I won't say too much about, again, this idea of trying to call the top cases in a given year. It's an important and interesting question, because it forces us to ask, and I think as educators, this is a question that comes up often as you're deciding what to focus on in the classroom. What makes a case important? Is it that it affects lots of people, that it's in the news? And we'll see in the case of Sullivan and Brown, in the news, not always in a simply descriptive way, but sometimes leading to misapprehensions or misconceptions about the case. Does that make it important? Or is it the significance of the change, either reversing course, overruling an earlier decision, or making new ground, breaking new ground under the Constitution, and so forth? Sometimes it's a compelling story. We'll see, of course, the Bissonnette case involving the tragic shooting at the mosque in Quebec City was an incredibly compelling incident when it happened. And of course, people have been focusing on that case in part because it involved such a notorious person at the center who was responsible for so much devastation. And then finally, sometimes it's just the nature of the legal story and what it inspired in response. We'll see that in the City of Toronto, Ontario case, where the threatened use of the notwithstanding clause, if the initial court decision striking down the Ontario government's measure to change the ward boundaries wasn't altered, that was going to be the government's position. So was that, again, a new dynamic in our justice system, and of course, lots of hand-wringing about what that could mean. So all of these play a role in deciding on what cases matter, but of course, it's never lost on us that very few cases ever see the light of a courtroom, never mind an appellate courtroom, never mind the Supreme Court of Canada. They decide fewer cases now than they used to. It's about 50 cases a year now, and it used to be 80 or 100. And of course, it's only by leave. So it's the rare case that is seen as nationally significant enough to make it to the Supreme Court to begin with. All right, so without more wind up, let's move to the pitch. Case one on Sullivan and Brown. These are companion cases that really raised the issue of this notion of automatism as a defense to serious crimes. And that is to say, when notwithstanding the fact that a person did something, committed an assault, and in these cases engaged in stabbing and quite violent incidents in the cases of in Sullivan against parents, and in Brown and against people in their home. The argument was in the defense that they were sufficiently intoxicated on narcotics. Magic mushrooms in particular formed part of the backdrop of each case, that they weren't responsible for their own conduct. They weren't acting in a voluntary way. In other words, if I push Nat into Jess and Jess suffers a big injury, then I may be held responsible, but Nat wouldn't. He didn't voluntarily seek to harm Jess. He was pushed by me. So can you say the same thing about someone who is so high on drugs that they're no longer in control? They're effectively not responsible for their own actions. And of course, this caused a lot of consternation around intoxication with alcohol in particular, and the idea that a number of cases in the especially early 2000s had involved people arguing that they were too drunk to be held responsible criminally. This led, of course, to lots of concern, particularly in the community of advocates for victims of sexual violence and other crimes where alcohol can form a significant part. So Parliament enacted this provision of the criminal code that effectively removed automatism as a defense for certain kinds of crimes, serious assaults, sexual assaults, and so forth. And the provision that was under scrutiny is here and effectively does what it says. It takes away as a defense self-induced intoxication that affects the voluntariness of someone's action. But the problem for the court in these cases, again, where there was expert evidence, so we take it as given that the individuals were not able to control their activities, that voluntariness was not present in the commission of these offenses, is that this takes away a fundamental element that the Constitution requires in order to convict someone of a crime that's going to take away their liberty, potentially, which is a mens rea, that they intended the act, that they were responsible for the act. And they instead create effectively what the court said was an absolute liability offense, that if you are responsible for that assault, notwithstanding that you had no control enough to form a mental element to do the act, you would be held liable, you would be convicted, you would be imprisoned. And the Supreme Court emphasized that this wasn't extreme intoxication in the sense of having way too much to drink, that this is intoxication is not a defense to violent crime, but automatism has been. And automatism, again, is distinguished by the need to have expert evidence showing that lack of voluntariness. And the court was at pains to say this could virtually never be established on the basis of alcohol alone. And in fact, if you went out intentionally to drink so much so as to become in an automatism, state of automatism to commit a crime, well, then you couldn't be in a state of automatism because you would already be executing a strategy which is the opposite of what automatism leads to. So the court struck down the measure. It had been, again, a high-profile case because of the especially implications of this for those other settings. And the court tried to make clear that this doesn't change anything to do with people who are committing assaults when they are intoxicated generally. That said, as I'm sure you, those of you who heard the earlier OJEN session on Sullivan were aware of, the coverage by the media focused on effectively this as some kind of get out of jail free card, that if you're high, you won't be subject to criminal accountability for what you do. And again, the magic mushrooms, which featured in each case, became one aspect associated with it as well. So a number of people in the criminal justice community and the sexual violence advocacy community did what they could to clarify what the judgment actually meant. But it's an example, once the court puts out a decision that it really can't control what it comes to mean and how it comes to be characterized. So while there was a real concerted effort to clarify Brown and Sullivan, it still, I think, in the public imagination, represented a case where people who clearly were responsible for grave crimes got away with it because they were sufficiently high. And that's, again, not what the court said, not what the criminal justice process concluded, but it's certainly what was out there in some aspects of the media, particularly social media. So it's a cautionary tale. All right. Obviously, we could spend more time on all these cases, but I do want to leave some time for discussion. So I'm going to be a bit more touching on the surface of these cases than delving as deeply as they justify or warrant in each case. As I said, the Toronto and Ontario case, the second of the top 5, received a lot of press as well, not just because there was an election ongoing at the time. The wards were reduced, I think it was from 47 to 25, but also because of the Premier's former role as the city councillor, some of the media surrounding this issue, and of course the threat to invoke the notwithstanding clause after Justice Belobaba's initial decision striking down the measure as a violation of the freedom of expression under the charter. That led to a hearing here at the Court of Appeal in which 5 judges sat on, which is a significant, only for significant cases here. The normal grouping is 3. And it was a 3-2 decision, with the majority reversing Justice Belobaba and finding no constitutional violation. Excuse me. It went to the Supreme Court of Canada, where it was again a razor-thin 5-4 decision, ultimately upholding that majority of the Court of Appeal, that is to say, concluding that there was no charter violation. So of the 15 judges who had a chance to review this legislation against the lens of the charter, 8 judges found no constitutional breach, 7 found a constitutional breach. So to make the case that smart, committed people can disagree about some of our most fundamental rights, this case is a great teaching tool. And also what it does, which I think does have some resonance in a whole range of other aspects of how we teach the charter, is it really goes into some detail talking about the difference between positive and negative rights. There's a suggestion, again, from the majority that what the claimants in this case were arguing, including the City of Toronto, was for a positive platform on which to express views, as opposed to freedom from interference with the expression of views as a negative right. Again, a spirited dissent led by Justice Abella took real issue with that characterization and with the distinction between positive and negative rights at all. Similarly, there was a real difference in the majority and dissent on the role of unwritten constitutional principles. Principle of democracy, for example, which the majority was at pains to say on its own can't strike down legislation. It needs to inform the interpretation of some text of the Constitution, freedom of expression or some other charter right. Whereas again, the minority, the dissent pointed to a number of cases where those principles alone have been held to potentially, if inconsistent with legislation, lead to striking it down. The majority, by the way, did have an exception for the honor of the Crown in Crown Indigenous relations under Section 35 of the Constitution, which it left open as potentially being able to strike down legislation if a court found it inconsistent on its own. So fascinating, somewhat inside the weeds, but important weeds about how our constitutional architecture works. And again, I just got ahead of my slide there, but I've covered this material in terms of the substance. And of course, now we've got a municipal election in Toronto with 25 wards. Some say the sky didn't fall. Others point to how the number of people running is less than back in 2018, and of course how those individuals can serve and represent communities that are now substantially larger than they used to be remains another kind of contest. But it also speaks to a premise of this case, also important, I think, from a teaching point of view, is that from the Constitution's point of view, there are only two levels of government, federal or provincial, leaving aside Indigenous as a not a separate level of government, but a separate constitutional order of government. Municipalities are not government from the standpoint of the Constitution, in that they have no right to be a particular size. They can be changed. Municipalities can be established. They can be repealed. We had the mega city case some years ago in Toronto when the boroughs of Toronto were all merged into one. So it's government in terms of if municipalities do something, it has to be subject to compliance with the charter and so forth. But it's not a level of government on a par with the province and the federal government. It remains a creature of the province to be ordered as the provincial legislature sees fit. And again, that's this case is a kind of emblematic of how that can play out. So the Bissonnette case, and this is a shot from the mosque where the shooting happened, is clearly one of the cases that goes to the fundamental search for humanity in our constitutional and criminal law. It's hard to imagine a more devastating crime than the 2017 murder of 6 people simply for being in a mosque exercising their religious observance at a time when this individual came in looking to take lives. As a result of the conviction, there was a discretion around how long to make the sentence before parole eligibility could flow. So based on this discretion, the trial judge ordered that Mr. Bissonnette serve a total period of 40 years before being eligible to apply for parole. Given his age, this would effectively mean he would not be eligible in his lifetime. And there was, again, a criminal code provision that permitted this discretion that was subject to the charter challenge under Section 12, the protection from cruel and unusual treatment. And the Supreme Court agreed with the Court of Appeal from Quebec that anything beyond the 25-year parole ineligibility that flows from a first-degree murder conviction would offend the charter. So that's to say you can have 7 first-degree convictions, but those 25-year sentences before parole eligibility would run concurrently, not consecutively. And the reason for that is important, and I'm not, again, in any of these cases, looking to rehearse all of the chapter and verse of what the court had to say, but every now and then, I think it is really important to focus on the language used by the judges of the court, and again, as a teaching tool, to see how those judges grapple with some of the most fundamental questions facing our society and our communities. And in this case, it was trying to give meaning to when a punishment is cruel and unusual. And again, the language chosen by the court is connected to whether it could, the punishment in question, be imposed consistent with human dignity in our society. Or is it, in the words of an earlier decision, Suresh, dealing with the deportation of someone to potentially face torture in their home country, is the punishment so inherently repugnant that it could never be an appropriate punishment, however egregious of the offense? And is it, by its very nature, degrading, dehumanizing? And the court took the view, and I won't make you try to squint to read the paragraphs that follow, but I put them on the slide because, again, I think it really goes to something that every classroom discussion could could benefit from taking as a point of departure, which is notwithstanding the horror of the crimes, what does human dignity, the fact of being a human being in this society, entitle you to? And one is the possibility of rehabilitation in our criminal justice system. So at paragraph 146, the court writes, the horror of the crimes, however, does not negate the basic proposition that all human beings carry within them a capacity for rehabilitation, and that accordingly punishments which fail to account for this human quality will offend the principles that underlie section 12. So sure, 25 years is a bright line. Why not 20? Why not 15? Why not 30 or 35? But this proposition that there is no crime so vile, so egregious, so offensive to our sense of what's right, that it would justify removing such a fundamental aspect of what it means to be human, that possibility of rehabilitation at some point in life. So an important case from a practical point of view, because it clarifies that 25 years is the maximum sentence someone can receive before parole eligibility, but also philosophically shows the basic questions that in 2022, 2021, our court continues to grapple with in again, ways that no doubt are informed by changes in society. And we've seen this before, and what will shock the conscience, what will be a facet of human dignity is not necessarily a static thing. It will change as society changes as well. So in this case, because this section authorized a length of time before realistic possibility of parole beyond the lifespan, in this case, it was held to be intrinsically incompatible with human dignity. So the things you hear in the US, people sentenced to 120 years to 200 years, this can't happen in Canada. No one is beyond redemption is the takeaway line. Moving on to the fourth case, Stairs. And this is a shot, by the way, of Aaron Dan and Anil Kapoor, the lawyers involved in this challenge. As I said, it features the unending tension, I think, between what is a justifiable scope for police searches without a warrant and what is the non-negotiable right of privacy within one's own home. So in this case, there was a person who saw the accused and a woman in a car, and it appeared to the person viewing it like the woman was being assaulted, called the police. Police followed the car to this home. The door was ajar. No one answered when they announced themselves, so they are worried for the woman's safety. They break in. They don't break in, they walk in. They ultimately find the woman with some contusions to her face, and ultimately then in the basement, they hear noises, find Mr. Stairs, and arrest him. All of this involving the potential for violence against the woman involved. But once they're in the basement and once the arrest has happened and it's safe to look around, the police look around and find a bag containing methamphetamine and drugs that lead to a charge of trafficking. And so the defense is, well, police never had a right to look around the home without a warrant, and so the drugs seized should be excluded under the charter. In fact, entry into the home was not lawful in these circumstances, was the argument as well. Supreme Court, again, in what's become a pattern in some of these cases, did not speak with one voice, but again, split 5-4 on the correct standard for the right to be free from unreasonable search and seizure under Section 8 of the Charter. In the most senior and most junior judges from Ontario combining to write the majority decision, the search was incident to the arrest, which is an existing rule at common law was affirmed and arguably expanded so as to authorize police officers to search an area proximate to an arrest where there is some risk to safety, and this led to, again, upholding the search in this case. The test that was approved by the majority when searching the area of the home not under the physical control of the accused at the time of the arrest, and that would fit the scenario in the Stairs case, police must have a reasonable suspicion that there is a safety risk to the accused or officers of the public, and it must be a narrowly tailored search. And again, for the dissent, they were looking for some more imminent risk to safety than was the case here, where again, the arrest had already happened. There didn't appear to be any real imminent risk at the time the bag of drugs was actually found. So the majority again found that this was a legal search, and the dissent not only would have focused differently on the test for imminence, which would have narrowed that scope for warrantless searches, but worried generally about what used to be a sacrosanct area in criminal law, the idea of being safe in one's own home from warrantless searches has clearly been chipped away at, and that was the debate coming out of this case. It has the pendulum swung too far towards the police and too far away from privacy in one's own home. So again, 5-4, there's a new judge in town. We'll see how these cases play out in the year or years to come, but clearly it wouldn't take much to have reversed the majority in dissent in this scenario. Okay, last case, and still looking to leave some room for discussion coming up shortly, is the one I mentioned dealing with self-defense, and the individual at the center of it is pictured here, Mr. Keel, who awoke one morning to a sound outside his property, grabbed his shotgun, went out, announced himself, thought he saw the person in the car going for a weapon, shot him twice, and then was arrested for the murder. So under the criminal code, a person is not guilty of an offense if they're acting in self-defense, and the definition here is set out from the criminal code, and it's been revised recently, and the focus of the analysis, certainly in this case, as in many, will be on that third element, that a person will not be guilty of an offense if they act in self-defense and the act committed is reasonable in the circumstances. Of course, not the first time reasonable in the circumstances will find its way into your classroom discussions or into the criminal code or into our legal system, but it can seem sometimes hopelessly subjective. So the criminal code, again, in this new iteration of self-defense, helps us out with a list of a number of factors that can inform whether an act committed was reasonable in the circumstances. And the highlighted subsection, the person's role in the incident, is what was at issue in this appeal. This particular subsection wasn't focused on by the trial judge in instructing the jury on how to approach this. The jury, by the way, acquitted Mr. Keel, said the shooting was reasonable in the circumstances, and focused on that moment of the shooting itself, seeing someone reach for what he thought was a weapon and so forth. But the Supreme Court said, well, that's not how this should work, that when you're looking at reasonableness, you need to look at the person's role in the whole incident. Why, when he woke up and heard a sound, did he immediately reach for a gun that was loaded? Why did he not take other steps to see and investigate what was happening and whether it was in fact any threat to himself or his family? So all of those things, in other words, that preceded the actual shooting, the court held, are part of the analysis because of this focus on the person's role in the incident. And for that reason, the court held that a new trial was going to be required. And again, I've got a slide here talking about the incident itself as I've described it. and some of what the 5-judge, again, another split decision, 5-judge majority found important about that accused's role in the incident, including what led to the incident. And when I say what led to the incident, that includes not just what was done, but what wasn't done from beginning to end. So for example, not calling 911 to call for the police to intervene if you think there's a threat from a car outside, but instead to confront the intruder with a loaded gun. Was that reasonable? And here the court's not saying it wasn't. The court's not imposing a conviction. The court's simply saying a jury needs to be informed of all that before it can reach an appropriate decision on conviction. The jury here wasn't given that instruction. And so again, the result of this is a new trial. And there's again some discussion in the case of this new, not new so much anymore, but 2012 legislation that had changed self-defense, the Citizens Arrest and Self-Defense Act, and effectively sought to broaden situations where self-defense is available. But here the courts, in fact, using that resulting legislation arguably to narrow the categories of self-defense by expanding what it means to have acted reasonably to all the conduct leading up to the event, not just the incident or event itself. So I hope that's clear. And again, if not, happy to go over it. And then again, from a teachable moments in the case, particularly like this paragraph, that self-defense is not meant to be an insurance policy or self-help mechanism so that you can take the law into your own hands. And it's clear that notwithstanding this attempt by Parliament, in effect, to encourage more self-defense, the Supreme Court sees it as the law always should encourage peaceful resolution of disputes and should not condone the unnecessary escalation of conflicts, notwithstanding what that legislation might have been taken to have meant. Okay, so that's the 5. Just before I finish and open up some time for a back and forth, I said I would mention a case or two to watch out for. One was actually in the news this week, dealing with Premier Ford's mandate letters and whether the public has access to them. It was in the news this week because the government has also denied access to a request to get the quantity of funds spent on the legal defense of continuing to hold the mandate letters secret, confidential. And so that case is also moving through the system, but the Supreme Court will hear the initial decision and appeal from this court that had found the mandate letters should be subject to disclosure, which had been the finding of the Information and Privacy Commissioner. So this court and the divisional court below this court had both upheld the commissioner's decision to release the mandate letters. That all now goes to the Supreme Court in this next term, as does the really important Safe Third Country Agreement decision dealing with refugees and whether they can be turned away to a country deemed to be a safe third country, and what that might mean, again, for the extension of charter rights for those caught up in the immigration refugee system. So again, an important one on international conventions, immigration refugee law, and the charter. Finally, I mentioned the appointment of a new judge, but we should also note the retirement of the judge she's replacing, Michael Moldaver, who is former judge of court that I'm on, the Ontario Court of Appeal, long-serving member of the Supreme Court, was one of the last unilingual Supreme Court judges we may see for a long time, and also a real expert on criminal law, and Stairs is simply one of many major criminal law decisions that he's authored over his years on the bench, or co-authored in that case. And of course, many people thought we're going to need a criminal law specialist to replace Justice Moldaver, which Justice Lorne Sossin certainly has exposure to criminal justice, but that was not her main focus of activity, either in practice or as a judge. So there's some, again, lingering questions about the overall depth of the Supreme Court's criminal law background. On the other hand, we, of course, apportion Supreme Court appointments by region and arguably other factors of demographics now formally or informally, but subject area specialty only becomes relevant in those 3 judges from Quebec, which are said to be a requirement so that there's always a panel that can hear civil code matters. But in the case of something as important as criminal justice, we see the majority of the 5 cases I've listed are from that domain. There is not any requirement that a Supreme Court judge come from that background, but certainly the absence of Justice Moldaver will be commented on in relation to those criminal law judgments to come. So with all of that, some resources you may already be familiar with, the terrific Supreme Court plain language case summaries that I think are just absolutely ideal for teaching purposes. Charterpedia, many of you will know, is a justice initiative to try to get more accessible understandings of the Charter out there. And a plug for my alma mater, Osgood, where the court.ca continues to be a leading blog for case comments almost as soon as they come out, including all the cases I've talked about today. There's a court.ca piece on. So with that, let me again thank the organizers for including me. Hope I didn't go too fast through any of it, but we've now got some time as I end the share to hear from you or to chat about any or all of the cases.
Well, so thank you. That's fantastic. What an interesting group of cases. And my goodness, I'm struck by just how difficult some of the questions are that you encounter when you're doing judging. You know, it reminds me of some of the try judging exercises that we've seen, and like these are pretty complicated. We do have unsurprisingly a nice queue of questions already. I'm going to just horribly abuse my power for just a moment and ask you to comment on something, because I hear a lot in the cases that you've chosen, or that you and your clerks have chosen here, a lot around unwritten principles and a lot around these areas of the law that are not specifically and sort of directly addressed in terms of like the limits of proportionality, for example, in sentencing. So if you can conceive of a crime as being limitless in terms of its capacity to offend the sensibilities or the public, but then you have this notion that there's a thing called human dignity, which becomes an absolute ceiling for the extent to which the justice system can respond in proportion to the actual crime. And then, things around all of the really close decisions, like in the Toronto versus Ontario. I was not aware that in total judging, it was 15-14. That is something else. That is a big one. And I just, I wonder about if you have any thoughts on whether whether the notion, like things like positive rights that are not specifically written in, are going to be more important for appellate courts to deal with, and why that might be, if it's the case.
Well, I think the main takeaway for me on looking at these cases as a whole is one of, should be one of, I think, real empowerment for people, whether in a classroom or a courtroom, to take on these issues. That as we're seeing so many divided cases on such fundamental questions like positive versus negative rights, it shows that each generation is going to reinvent the Charter to reflect those social priorities and norms. We have, a very tree-hugging approach, as we like to say, that it's a living tree, our Constitution. There is really very little spirit of originalism that somehow what this group thought in the 1980s is going to define the Charter for all time, never mind the 1780s, as is the case south of the border. So that idea that we're still wrestling with fundamental questions is, I think, an important counterpoint to the view sometimes that, well, all the big Charter cases are decided, the big constitutional issues are settled, We're now just poking around the margins. So I do think those are big questions. Just on the human dignity one, though, I think by saying the human dignity is about rehabilitation, it actually raises an important puzzle, which is, do we treat young offenders different than old offenders? Because a 25-year sentence to an 80-year-old might in fact mean there's no possibility of rehabilitation. We think of rehabilitation more as a young person, as was the case in a relatively young person in Bissonnette, having another chance at life to do things differently. So, how much of this is about bright lines versus contextualizing decisions so they're proportionate to the individual is again something criminal law wrestles with all the time, but it's an important challenge for understanding that aspect of human dignity, I think.
Super. Thank you. Now I have two questions that that sort of center on Cahill. The first is just a sort of a procedural question. Why does the Supreme Court send it back to retrial rather than making a decision at the time? And then secondly, maybe speak about the relationship between the decision in that case and say Colton Bushy, in which, a similar situation, arguably self-defense and so forth, and how those two might interact with one another.
Yeah, so first on the sending it back, it is often, a little bit frustrating because it's clear from the majority's reasons, at least between the lines, if not in the lines, that they have real reservations about whether this could have been a reasonable shooting in the circumstances, given all the choices that Keel had and didn't make, to wait, to call 911, to wait for a response after he announced himself, to figure out what was going on, rather than simply to take a loaded shotgun out there and shoot at the first sign that he thought the person might have been reaching for a weapon. There was no weapon. There was a knife apparently on him, but no weapon that he could have from inside the car caused harm. So it's a natural question to say, well, why didn't they just impose a conviction? And the answer is respect for the jury system, that it's a jury of one's peers that decides on convictions. So the issue in the case was not that the jury got it wrong, but that the trial judge committed an error in instructing the jury by not focusing on the individual Keel's role in the incident from start to finish. So properly instructed, the court would say, well, we don't know what a jury would decide, and it's up to the jury to decide. We just are here to correct the legal error, which was the improper instruction by the trial judge. But of course, this leads in practical circumstances to trials, retrials. So I was just on an appeal the other day that was a third trial for a matter that had 2 mistrials. So 7, 8, 10, 12 years after these events, you're still getting these cases litigated. It's incredibly frustrating for the families involved, and of course, not a great look for the justice system sometimes, but it's a way of saying we care so much about getting it right, including respect for the role of the jury, that the response here is a new trial. And as for the Colton Bushy Stanley case, and again, Colton Bushy was the victim of the crime. It was Stanley who was on trial. It is an important context, because what was so relevant in that case and led to such an outcry after that case was the cultural context, was who these people were and their relative positions in their communities and what was assumed about them and so forth. And it's clear that reasonable in the circumstances has room to import a lot of that. In this case, by the way, Keel had a military background, and some were suggesting, does that mean you're reacting differently when you have military training to someone who doesn't? Court made clear it ought not to, that self-defense has to be what's reasonable objectively, not just what's reasonable for that individual. And arguably, that's what led to the frustration in the Stanley trial of the killing of Carlton Bushy, is that there wasn't room to have that important discussion. So that's a tension, I would say, just to finish the point. Keel won't resolve, but I think reading them together can be an interesting juxtaposition to see how these factors play out in a context, again, where the issues of racism, issues of different resources and standing in society all played such a key role.
Interesting. Thank you. Back a little bit to Bissonnette. This is an interesting question as well. So given the decision there, how would you imagine that would affect or interact with dangerous offender provisions?
Well, it's a good point because, of course, dangerous offender provisions can take away effectively that eligibility for parole and can lead to a different outcome than the sentencing. So this dealt with sentencing discretion, and in that sense doesn't have any direct impact on dangerous offender provisions. And yet, of course, as this notion of human dignity evolves and the idea that no one is beyond redemption, Bissonnette will certainly have implications for cases to come that may continue to challenge that. And I think it would be, the problem is for something like Bissonnette, you're making a statement now about the future that for the next 40 years, the effect, in this case, natural life of the person, there's no eligibility. Whereas dangerous offender provisions, again, can be changed over time and revisited. So you don't have that sense that for the rest of someone's life, they're going to be effectively denied that opportunity because of that initial determination. So I think it is different in some respects, but that notion of how dignity interacts with the possibility of redemption and rehabilitation clearly is going to apply there and across the criminal justice system.
That's great. So you mentioned the Safe Third Country Agreement case coming up. One of our attendees has asked if there are any other ones or any other issues that you think are going to be likely to appear before the Supreme Court or appellate courts in the year to come.
Yeah, well, one to look for, and there's a couple of good mainstream media editorials on it if you're looking for teaching materials, is a view that's certainly prevalent in the criminal defense bar, that the Supreme Court has kind of lost its way on what fundamental due process rights are all about because of the societal pressure to come down on the side of victims of sexual violence. And so they look to a number of sexual violence related cases and find in almost every case, the balance has tilted towards the victims' rights, the police's discretion in order to find convictions versus upholding the rights of those who are accused. And the assumption or implication of the criminal defense bar is that this has more to do with a kind of outcomes-based approach to what the messaging from the Supreme Court ought to be in cases of sexual violence, as opposed to looking first and foremost to the protection of charter rights. And of course, there's pushback in other communities. So, but it's an important debate that as more of these cases, and the Supreme Court seems to just be highly focused on cases of sexual assault and sexual violence in terms of what it gives leave to, and how unsettled some of these new provisions are. For example, providing counsel to the victims who can play a role in determining what sexual history or other evidence is admitted in these criminal trials are getting more complex, more fraught. And of course, to the sexual violence advocacy community that is victim focused, survivor focused, the trial process itself is looking more fragile in terms of its credibility, because outcomes do matter, and especially the impact of those outcomes on the survivors and their families. So that tension, I'd say, is one to look for, especially with an important transition from Justice Moldaver to Justice Lonsowin. So keep your eyes on that one, in addition to some of the individual cases I mentioned.
That's fantastic. And with that, we could go on and on and on about this, and there are questions, but it's 10 o'clock. And the wheels of real justice are waiting for you. So I'm going to end the session now with our deepest thanks for presenting these cases. They're fantastic, and I can see teachers getting a great deal of use out of them. So I'll ask everybody to thank me, or join me in thanking you for taking the time to be with us once again this morning and this year.
And
Thank
thank
you
you
so
so
much.
much, Nat, Jess, and everyone for attending. And as I said, if you have questions I didn't get to or something occurs to you, get in touch with OJEN or with Nat, and they'll get me the messages, and I'm happy to respond. And really appreciated the chance to start my day in a stimulating way with you.
Take it to the bench.
All right, thanks. Take care.
See you.